number 32, the people of the state of New York versus Darryl Brown.
I would like to reserve 4 minutes of my time for rebuttal with the Chief Justice's permission.
You may, 4 minutes.
Thank you.
Counsel, if an initial aggressor who introduces deadly physical force into an encounter can shoot and kill the person who's trying to grab at the gun, what does that do to the limitations set out in Article 35?
Well, Your Honor, initially, the word grab was defense counsel's word. The eyewitness, the mailman.
Oh, I'm talking generally. I'm not talking yet
generally.
specifically about this case.
Right. Well, Your Honor, it's obviously a very fact-specific determination. There may be instances in which it's warranted versus not warranted, but under the circumstances of this case, where we have no evidence, no reasonable view of the evidence indicating that there was ever any use of physical force, deadly physical force on the part of the victim, Mr. Cabbagestock, there was no reasonable view of the evidence that warranted the justification charge. And the appellate division was incorrect in finding otherwise.
But if there's a witness who's testifying that the victim is grabbing, punching, swinging, excuse me, getting in the face of the defendant, why isn't that enough to give you that reasonable view of the evidence that permits a justification defense?
Well, Your Honor, first of all, again, the word grab was defense counsel's word. The word that this particular witness, Mr. Wolf, used was swipe. Mm-hmm. And what Mr.
Let's use that word.
Sure.
It's obviously an attempt to get at a weapon.
I would disagree with that characterization. But even if Your Honor would disagree,
but isn't there a
with my
reasonable
disagreement,
view that might be the way the jury sees it?
But assume that's the view.
let's assume that's the view.
So what would the
Yeah.
answer to Judge Rivera's question?
So the answer, Judge Rivera, is that if the encounter were to end there, then I would be more inclined to agree with Your Honor. However, that is not what actually happened under the circumstances of this case. Under the circumstances, we have a 45-second window during which the witness in question, Mr. Wolf, the mailman, is, according to his own testimony, up a flight of stairs out of eyesight of the defendant and the complaining witness. The only person who actually sees what happens next is Ms. Thomas, who testifies that, in fact, the defendant, Mr. Brown, walks away from Mr. Cabbagestock, and that Mr. Cabbagestock follows him from several feet behind with his arms outstretched, trying to reason with him. At that point, they walk past her field of view, and then she hears the shot.
But they've been in that encounter. The victim is following the defendant quite closely, and obviously they're continuing to engage in some form or another. Why is that still not? Remember, it's not a de minimis threshold, but it's not a high bar. Right? It's a reasonable view of the evidence.
Well, Your Honor, keep in mind that the testimony was that the defendant was angrier than Mr. Cabbagestock. Mr. Cabbagestock had his hands up, his palms facing upward, trying to reason with him, and that they were at a distance of 6 to 7 feet.
That's, again, part of that is sort of the witness saying that's what she thought all of that reflected, because as I recall, she doesn't really hear them, right? She doesn't say she could hear them.
That's correct, Your Honor.
So again, the jury can discount, accept all or any part of any testimony. Why isn't it, given the range of what occurred, why doesn't, I'm still not understanding why it doesn't give you a reasonable view. I mean, I understand the dissent's position, which is once the defendant appears to be going for his gun or has his hand on the gun, that now he's an initial aggressor, you have a whole different situation, he's not entitled to the justification defense. But you're arguing that that scenario of facts based on this testimony doesn't even meet this very low bar. And I'm not understanding that.
Well, Your Honor, the jury certainly can accept or reject testimony, but they cannot, however, imagine testimony that doesn't exist.
But they can draw reasonable inferences.
That's true, but there's no testimony whatsoever in the record that contradicts Ms. Thomas's testimony. She was the only person who could see the defendant and Mr. Cabbage-Stock in the second leading up to
I thought there was
the shot.
testimony by Wolf that the defendant kept backing up. He says it 3 times. He backed up, he backed up, he backed up.
He indicated that the defendant was leaning back. This was earlier in the encounter when there was still the third man.
So he doesn't say he continued to back up, back up, back up?
He indicated the defendant was leaning back, but that he wasn't
No, but that wasn't my
retreating.
question. Did he say that? Did Wolf say that? Was there testimony in the record that he continued to back up?
Okay, yes. And he's leaning back. This is earlier when there's the third man, before the third man leaves, before the gun is prominently displayed, and Mr. Wolf sees the gun and, in his words, goes upstairs, right? Which is why, when the shot goes off, he has to come back downstairs in order to see what occurred.
So, counsel, if we disagree with the way you've characterized this testimony and the interactions, does that end the inquiry? Does that mean that the appellate division is correct, that justification should have been charged here? If we disagree with the way you've characterized this testimony about what the interactions were, let me put it that way, between the victim and the defendant.
It's certainly a harder case for us, Your Honor, but I would still say that at the point where you have here, unlike in the previous case before Your Honors, you have here somebody who was undisputably the initial aggressor, who chose, as a corrections officer, to bring a gun and confront an unarmed man in the hallway of his
On
apartment
that point
building.
of bring the gun, is the record, the trial record, as opposed to anything that may have happened before trial, is that clear about that he had the gun on him already, as opposed to going to retrieve it from someplace else or anything like that?
Well, the testimony, Your Honor, was that the defendant came home from work, he goes into his apartment, and then at some point thereafter, he exits the apartment to confront his daughter's boyfriend, Mr. Cabbage-Stock. So he did have an opportunity to obviously leave the gun in the apartment, but he instead chose not only to have it on him, but to have it at his side, to be holding it when he's having what, by all accounts, was an aggressive conversation.
Do you know if there was...
To what extent does it matter, I'm sorry.
No, you go ahead, Judge.
To what extent does it matter whether it's at an angle, whether he's actually put his hand on it, whether he's drawn it? Is the mere fact that he goes into this fist fight with the gun, is that enough to make him the initial aggressor as a matter of law? Is that
I
what
think
you're
that
saying?
I understand your question. I would say yes, but even if Your Honor disagreed with me, the reality is that what he was saying, stay away from my daughter, don't come around here, he's angrier, he's the one who's having the heated discussion. Those indicators, which are throughout the record, would increase that level to which he is the initial.
Do we know if it was at least in his holster when the altercation began, rather than take it out of the holster and at his side? Do we know that?
I would have to double check the record, Your Honor. I believe that he took it out of his holster while the conversation was ongoing.
So you're
Does that
saying...
make a difference?
I think it does, because I think when you take all of those things together, you can understand why Mr. Cabbage-Stock and his friend, who was there and then left when it became clear that this was going to be a violent confrontation, it's clear why they displayed such concern.
So just let me ask it. Did the victim swipe at the gun before it was taken out of its holster?
No, Your Honor. The defendant was holding the gun at his side, and that was when the victim...
He was holding, so it already had been taken out
Yes.
when he began to swipe at the gun?
Yes, and to be honest, I don't recall whether there was testimony of whether it was ever in the holster or whether he emerged from the apartment with it at his side. I don't recall that.
And Wolf's testimony was inconsistent about in which hand Mr. Brown had the gun, right? It started one way and then he switched it to the other way and he wasn't sure.
That's possible, but his testimony was that the gun was at the defendant's side, and I'm sorry, I know my time has expired, but very briefly. It's at his side, and that is when Mr. Cabbage-Stock says...
In one hand or the other.
Right. And Mr. Cabbage-Stock indicates, you're going to pull a gun out, you better use it, and he's swiping. But again, all of that occurred well before the actual murder.
Thank you, counsel. Counsel?
Yes, may it please the court, my name is Joey Jackson. I've had the pleasure of representing Mr. Brown at the trial level, sitting through readback in the case, listening to the testimony, writing the brief, arguing it before
So
the
that's
first
great.
department.
So what exactly is the evidence?
So the evidence-
of the
and
threat
Judge,
of
let me just
deadly
say-
physical force by the
Yes.
victim?
So let me explain why I say that. I say that because on the issues of facts, I think there were misrepresentations, not intentional, but I say that to let you know that I believe I'm conversant with the facts and what was represented did not occur. Who saw the case was Mr. Wolf. Mr. Wolf, in seeing the case, posited a significant amount of testimony which would establish that Mr. Brown was in immediate fear for his life. What is that specific testimony? He posited testimony that would suggest that at the time of the critical moment where the shot was fired, Mr. Brown was moving back, to your point, moving back again, not attempting at all. At this point, the gun was out, Your Honors. It was out indeed by his side. It wasn't pointed at anyone. And when Mr. Brown was moving
Here's
back...
my question.
Yes.
If I have a legal license to carry a firearm, and somebody who is, well, there's no evidence, at least here, that the victim here was armed. So let's say somebody who was unarmed comes at me, and we're going back and forth, and maybe he's approaching me. Do I have the right to take out my gun and impliedly threaten, again, I'm making some assumptions, that person? Do I have the right to introduce a dangerous instrument into our confrontation?
Judge, most respectfully, I don't believe that that's relevant to the inquiry, and if Your Honor would permit me to say why. Now, in terms of introducing a gun into the equation, you could argue that potentially that's bad judgment, potentially it should not have been introduced. I think the inquiry begins when the gun is introduced into the equation. What then happens?
But my question is does that make, it matters to me, because the question to me is, did that make him the initial aggressor?
Okay. In terms of the initial aggressor, let me be clear. That issue was never brought up at all. That issue was not preserved before the court.
Well,
that issue was...
Let's just say
Okay.
we disagree with you.
Okay.
I think that there may be an argument that it was. I can't see how, I'm not sure how why the trial court would have ruled the way it did unless that was what it was basing it on. But anyway, let's assume that to be true.
Well, Judge, yeah, I don't know why the trial court did what it did, most respectfully, but
I
in any
understand you
event,
don't
moving on, I do not believe that that in and of itself would make him the initial aggressor. I think the fact inquiry regarding the initial aggressor is what then occurs. The gun is now out, not pointed at him. You would think under normal
Why
circumstances...
else would he take it out?
He would take out the gun. It would seem to me, again, a reasonable view of the evidence might be to end it, to say, look, there's a weapon, leave it alone. That's not what happened here.
Isn't that a threat?
Well,
If you keep doing this,
Ju-
then
well,
I'm going to end this?
But that's not what happened. What happened, again...
I know, but the question is we're talking about what is a reasonable view of the evidence, right? So-
And so my view is that I would believe that Mr. Cabbage-Stock was the aggressor, in as much as once the gun is out, he then says, Mr. Cabbage-Stock, if you have a gun, you had better use
Just
it.
clarify a little bit of the order here.
Yes.
Okay. So the gun is holstered?
Yes.
When the
Where's the
defendant
evidence-
and
where's
the
the-
victim first interact? And at what point does he pull out this gun?
What happens is that initially there's a confrontation between Mr. Brown and Mr. Cabbage-Stock. Following that confrontation, Mr. Brown then walks away. While he's walking away with his hands up in the air, Mr. Cabbage-Stock is following him.
Yeah.
He's following him. That's what Sheila Shake sees.
Where is the evidence in the record that the gun was ever holstered?
There's inferences.
No. Is there the word holster in the record anywhere? You're intimately familiar with it. Where is it?
There's not the word holster itself in the record.
Okay.
But we can infer, Judge Wilson, and let me explain why we can infer.
Well, then I'm not sure it's really fair to answer Judge Rivera's question about whether the gun was holstered by saying, well, we don't actually know.
Okay. So, right. So we don't
You know
know.
the record, you've accused your
Yes.
adversary of misrepresenting it, please represent it accurately.
Okay. So what happens is that when my client is walking away, when Mr. Brown,
And where's the evidence that your client is walking away with his hands up?
the evidence is by Sheila Shakes, AKA Sheila Thomas,
That
which
his
suggests
hands are up.
that she comes from grocery shopping. She looks in, when she looks into the vestibule, she sees at that point Mr. Brown, no gun at all, walking with his hands in the air, no gun. No gun in his hands at all.
Isn't her testimony that Mr. Cabbage Stalk is walking with his hands up with no gun at all?
No, that's not her testimony.
Right.
Her testimony is that Mr. Brown is walking, gesticulating with his hands, and that's why she could observe that he doesn't have the gun. So to your point about the holster, again, the inference could be made that after Mr. Cabbage Stalk approaches him, and then now we have the postman, which is Raymond Wolf, enter into the equation to see the critical moments that it occurs. So now, after the initial confrontation, when Mr. Brown walks away, that's when you have Mr. Cabbage Stalk following him. That's where you have the confrontation where he ultimately follows him, Judge Wilson, and in following him, now there's a confrontation where the gun, we could presume at some point it gets unholstered, because we know he didn't have the gun when Sheila Shakes sees them. And then we know Raymond Wolf is delivering the mail, now the gun is out. And when the gun is out, he now, that is Mr. Brown, becomes under attack. He's under attack in as much as he has the gun out. Mr. Cabbage Stalk says, if you have the gun out, you had better use it.
So is there a swing before the gun is out?
From my understanding, there's not a punch before the gun is out.
So the gun is out first, then first swing.
Gun is out, first swing. Gun is out, second swing. Gun
So
is out.
does he have to bring the gun out only when he's defending against deadly physical force?
Well, I don't think the issue really is, there are two cases that I would just like to think that this court should look at. One is the Schwartz case, and it's a First Department case in 1990, and it stands for the proposition that when you lunge at someone who has a gun out, irrespective of when the gun came out, and they discharge that weapon because they believe that you could either take the gun from them or otherwise overpower them or otherwise gain access to the gun, a justification charge would be warranted. That case does not speak to the issue of it's relevant when the gun comes out, how it comes out. It's relevant when the gun is out, says Schwartz, and there's a lunging for that weapon. That person who's getting lunged at has who might have an immediate belief that they're about to be attacked or otherwise have serious physical force used against them can shoot. Second case I would direct the court to would be the case of People versus Smith, standing for a very similar proposition, not in regards to when the gun comes out or should he have it out first, second, or third, but if a gun is out and whenever that gun is out and the person becomes under attack, then it certainly would be a view of the evidence that that person who introduced the gun even feels that they could be overpowered and the gun could be taken away.
Well, why aren't the people correct that you've got this altercation, but then the defendant is moving away, the victim follows him, Ms. Thomas sees the victim with the hands in the air. That's the hands in the air. I understand you're saying Brown has his hands at the air.
Yes.
Earlier, and she says she sees that without a gun. Why aren't the people correct that at that point, 45 seconds have passed, there's now moving on, and he's not in that moment where he's fearful?
Because that's not what happened. What happened is that the shooting came after the fact. What I'm suggesting to you...
No one saw the actual shooting.
Yes,
Is that
they
correct?
did. Raymond Wolf saw the shooting. He didn't see the muzzle flash. He saw everything leading up to the shooting except the muzzle flash. And that's what I want to be clear on. Facts here matter. And they matter very much because there was no dissipation of time. There was no 45 seconds elapsing. This happened simultaneous. Mr. Brown acted simultaneous to when he needed to act. When he did finally discharge that firearm, he was swung at once and he stepped back, says Wolf. He was swung at again, he stepped back, says Wolf.
So the basis for the reasonable view of the evidence that he's entitled to justification all turns on Wolf's testimony? If we just read that, is that your position?
Well, my position is that Wolf's testimony lends further credence to the fact that he would be entitled to that charge. Here's why. Because Wolf suggests, again, that he's swiping and grabbing for the gun. It's in the record. In addition to Sheila Shakes, who says she doesn't see anything, but she sees him leaving the confrontation. Mr. Brown had left the confrontation. It was Mr. Cabbage Stock, who then follows behind him and reinforces and goes after him and approaches him and otherwise ascends upon him, thereby Mr. Brown needing to defend himself.
Brown's back to him when he was,
Mr. Brown's back was, and this is Sheila Shake's testimony, Mr. Brown's back was away from Mr. Cabbage Stock, who was
it's your
behind him.
position, he spun around and shot him?
At some point, no, not spun around and shot him, Your Honor. He spun around when he continued to follow him, and after he continued to follow him, and at some point, which is unclear, the gun comes out. But it's not unclear in terms of the persistence of Cabbage Stock in swinging at him multiple times, in grabbing for that gun, and otherwise, in Mr. Brown's view, attempting to overpower him to get that weapon, and Mr. Brown attempting to do each and everything before the gun was ultimately discharged.
When Mr. Brown had his back to him, could he have kept walking to his apartment?
Mr. Brown, in terms of keeping walking to the apartment, my understanding is that at some point there was a confrontation such that Mr. Brown had to turn around, otherwise he felt that he was in danger. In other words, he couldn't just walk. This person's behind him using all kind of language, et cetera, et cetera.
Was he walking towards the door of his apartment?
The record is unclear about precisely, was it the door of his apartment? He was walking in the direction. I can't say
He was walking towards his daughter and the grandchild in front of the door, is that correct?
Right, in the direction. I can't say he was walking into the apartment. I can say he was walking in the direction.
No evidence how far he is from that door?
There's no evidence in the record in terms of that. It just, he spins around, and at that particular time, the confrontation occurs. And again, this was a situation where he was compelled to discharge the firearm based upon the surrounding set of circumstances and him feeling he was in immediate fear for his life.
Counsel, we've talked a lot about the facts and the perspective here, but let's assume, and I know these aren't the facts of this case, but let's assume there is this type of confrontation and the victim is getting loud, but not in any way physically threatening, and the defendant pulls out a weapon. Same angle, pulls out a weapon. I think we can all say at that point, you're introducing a dangerous weapon into this confrontation without any reason, right? The person's 20 feet away and just getting kind of belligerent. There's no other evidence in the record that he knew they were armed or he had reason to suspect they were violent. So they pull out a gun. Now that victim comes and starts to swipe at the gun. Would you say, and same testimony, swiping for it, would you say you would be entitled to a justification charge?
I think it depends upon the facts. Was there, as here, was the person being berated and being belligerent to the other person, number one? Number two, was the person wearing a long black coat at the time? Number three, did my client fear that
The problem is, assume that there is no reason to pull that gun out. We could all agree there's no reason, but now it's out. It's out. And now that victim is swiping at the gun.
Yes.
So do you get a justification charge?
I believe at that particular point, if the gun is out, I think, and the person is coming towards you and grabbing for the gun, and now you really feel that you're in immediate fear for your life, I think you do get a justification charge.
Isn't that a problematic rule? I mean, because you've introduced a deadly weapon into a confrontation where it has no business being under any stretch of the facts. And again, I'm not saying this is the case. And now all of a sudden you can say, well, they're reaching for the gun I shouldn't have had out. So I can get a justification.
Well, I'd answer that this way. I think the first thing is that those are not these facts. I think there's an argument to be made that the gun should have been out, number one,
Understood your
based
argument.
upon the manner in which he was being approached after Mr. Brown decided to leave the situation alone, and based upon a person being in close proximity to him and otherwise saying things to him that were pretty colorful that I will not, repeat in this courtroom, and based upon the person really believing that he could be under attack and he could literally be in a threatening
So
situation.
then your rule would be bringing the gun out would have to be justified initially.
I don't think, no, I'm not saying
Well,
bring.
that's why you're explaining all these facts to me, right? You're trying to justify him bringing the gun out.
Yeah, I'm not trying to justify it. I'm suggesting to you that that was the reason here, under these
So
facts.
how about, again, getting back to my hypothetical where these aren't the facts, it's out, now swiping, do you get a justification defense?
I think that it should turn on what happens in the critical moments leading up to the actually deadly encounter. Whether the gun's out, whether the gun's not out, the issue to me would turn on if a gun is introduced. I don't think the law says if you introduce the gun, you can never, ever get a justification defense under any circumstance. That's just not the law. The law would suggest that whether it's introduced or it's not introduced, once it's introduced, if you feel that you're under attack and you feel that you really could die based upon someone continuing to punch, to swipe, to grab at the gun, and to punch at you, even though you continue to move back, and you use it.
But the fear I know your light is out, my last question, but the fear that you're referring to is the fear that the attacker, the victim, is going to take the gun?
I think that's...
Is that the fear you're talking about,
I
as
think
opposed to
that-
just punching you and hitting you?
Right. The fear is that they're going to take the gun. It's not the fear that they're going to, beat you or whatever. It's the fear that they're going to gain control of that weapon, and they told you, if that's out, you had better use it.
Take the gun and shoot you is what you're saying, not just take the gun.
Exactly. Take the gun and use it against you in a way that's overpowering such that they can kill you, of course.
Thank you, counsel. Counsel?
Thank you, Your Honor. I just want to clear up a couple of things about the record. The record is clear that Mr. Wolf was upstairs at the time of this shot. Transcript pages 250 to 251, where he says, when the shot went off, I was upstairs. Later on, he says, I didn't see the flash, I just heard it. It's very clear. And then after that, later on in that same page, on page 251, he says after he heard the shot, he came back down. That clearly indicates that he was not looking at the encounter at the time that the shot went off.
Can I ask you, just so I'm clear on your position, you're not saying, are you, that the display of a firearm automatically constitutes a threat of deadly physical force as a matter of law?
No, but it is certainly something that should be weighed by the court.
Of course, it should be indicated, but it's not, the display itself is not an indication of anything as a matter of law.
No.
So if you took the display of the gun out of the equation here, would be there anything that would deny a justification charge other than the display of the gun in this circumstance?
Well, I think the fact that right before the shot, Ms. Thomas, who is the one who's able to see the encounter, and this is on pages 154 to 155 of the transcript, just want to make sure that I answer counsel's accusation that I'm misrepresenting, that the complaining witness is walking with his hands up, palms outstretched, trying to reason with the defendant. Then you have on transcript page 158, Ms. Thomas testifying that the defendant is walking away from his apartment door, not toward his apartment door, but away from his apartment door. That's on
Here's my
T1.
logical problem.
Yes.
My logical problem is if the display of a firearm in and of itself cannot constitute a threat of deadly physical force, then there must be something else here that constitutes that threat of deadly physical force as a matter of law. And if not, then it's a question of fact as to whether, let me finish, as to whether or not it's that threat of deadly physical force, or that it can be justified, or that threat of any force can be justified here. So when you take the display out, what's left?
Okay, well, Your Honor, let me back up. Maybe I misunderstood Your Honor's question.
It's all right.
And I'm
Go ahead.
citing here to People v. Dote, which is a 1984 case from this court where the court says, so long as the gun is operable, it constitutes deadly physical force. So certainly we had here a threat of deadly physical force.
Yeah,
At the time
I understand that. My question to you was, if you take the display of the gun out, which everybody agrees, display of a gun in and of itself does not constitute deadly physical force as a matter of law. Maybe a question of fact, but not as a matter of law. Take the display out here. What other facts support the failure to give a justification charge?
The fact that we have the complaining witness 7 feet away, palms outstretched, trying to reason with Mr. Brown, and at that point the defendant is angrier, more aggressive. All of this is on in the transcript pages 154 to 155.
And that's the characterizations by
That's Ms.
Thomas,
Thomas.
right? Because she doesn't hear anything,
That's true.
correct?
She's looking through a
And the
glass
jury
door.
could
What about
discount
their
that.
physical sizes? How does that factor in?
I'm sorry, the physical
Physical
sizes.
sizes.
Well, okay, So in terms of their physical sizes, you have a corrections officer who, by the testimony of his own witness, is trained to handle a gun. He's 55 years old, 5 feet 9 inches tall, 200 pounds, in apparently good health. So not Mike Tyson, but certainly someone who can handle himself. And you have, on the other hand, Mr. Cabbage Stock, who's 21, 5 feet 11 and a half inches, so they have an inch difference in their heights, 187 pounds, maybe 20 pounds different in their heights, and also in apparently good health. So you have two men who are capable of handling themselves. You don't have circumstances that this court has discussed in the past where you have two clearly unequal people in this altercation. The difference in this case happened to be that one of them had a gun and knew how to use it, and the other one did not.
But if they're, as you're suggesting, sort of equally positioned in terms of sort of body height and so forth, then the defendant could be fearful that this other person is physically able to take the gun and use it on him.
It's theoretically possible, but the circumstances don't indicate that. And here, Your Honor, it's true.
It's not about theoretically possible, it's whether or not you've got a reasonable view of the evidence that supports it.
Right, and so for that, Your Honor, it's certainly true that the jury can accept or reject parts of any witness's testimony. What the jury can't do, and what the appellate division shouldn't have done, was to imagine something that's not actually supported by the record.
So from your reading of the evidence, who, if anyone, saw the actual shooting?
Nobody saw the actual shooting. What happened was Mr. Wolf saw the initial altercation. He goes upstairs. It's undisputable from his testimony that he was upstairs when the shot
So we're
went
left
off.
with the jury then
We're
having to
left-
deal with whatever this testimony is,
Right.
drawing reasonable inferences, right?
Right, and we have Ms. Thomas watch the two men as they're
So
walking
I understand your
across the
argument is
hallway.
about this 45-second break.
That's correct.
I understand.
And when you could take that 45-second break into account, and what Ms. Thomas sees, she says it's seconds. That's what her testimony is. After they go out of her line of sight when the shot goes off. But the last thing that
The
anybody
fact is,
sees...
no one saw what happened in that moment.
Correct. Nobody saw what happened in that moment. And that in itself, that absence of evidence, under the circumstances where you have one with a gun, there's no indication that there's anything other than an attempt to reason that's being answered with aggression, there's simply nothing in the record to support the reasonable inference that there was any sort of justification here.
Thank you, counsel.
Thank you.